After I developed the theory of atmospheric trust, several elements were in place. Number one, the nations are co-tenant trustees of the atmosphere. They all have this duty to protect the atmosphere as trustees. Number two, the citizens are present beneficiaries of this trust with rights to enforce this duty of protection. Number three, the future generations also have rights declared under hundreds of cases in U.S. case law. Future generations have rights under the public trust. But we were missing something, and that was, how do you characterize the fiduciary obligation to protect the atmosphere? What does that even mean? How do you take that to court? Or how do you take that to your city council or to your legislators? Can you just go to a legislator and say, I demand you bring the atmosphere back to equilibrium? No, we needed numbers. As attorneys, environmental lawyers, we work with scientists. And so I had to bring my approach to the scientific community and ask, what is the duty of protection quantified in terms of levels of carbon dioxide reduction or greenhouse gas reduction measurable on a yearly basis? And so when I brought my approach to the scientific community, my question always was to them, what is the duty of protection? What will it take to protect our atmosphere in terms that government can understand? And the scientists would often say, well, we have to get back to 350 parts per million of carbon dioxide in the atmosphere. That's the limit of the safe zone for the planet. We're now, of course, over 400 parts per million in an extreme danger zone. So we have to get back to 350 parts per million. But if you think about it, lawyers can't really use that number. You can't go into a courtroom and say, Judge, give me 350 parts per million for the atmosphere. You have to take that number and translate it into action that can be ordered or demanded by the people on the local, state, national levels.